Winner. Good.
Thank you. This is the matter of KLASS versus Liberty Mutual. I believe we've extended the time to 45 minutes. Is that correct? Am I the only one who believes that?
I wasn't aware of that, Your Honor, but
I think that's the case next Thursday, Chief Justice. Yeah.
My apologies.
Yeah.
Thank you very much. Each side has 30 minutes to argue. The appellant may reserve any portion of that time for rebuttal. Counsel for the appellant, please identify yourself for the record and let me know how much time, if any, you wish to reserve for rebuttal.
May it please the court, Your Honor, my name is John Donovan. I represent the appellant Liberty Mutual Insurance Company. I'd like to reserve 8 minutes for rebuttal, please.
Thank you very much. Senior Associate Justice McDonald will be our timekeeper. Can you see him?
I can, Your Honor. Thank you.
Thank you very much. He'll let you know when there's 5 minutes, 3 minutes, 1 minute, and your time is up. On this virtual platform.
Chief, that was 8 minutes, right?
Yes.
Thank you.
Because we're on a virtual platform, the justices will either raise their hand or their little yellow hand on Teams. When you see that, please, when you get to your next logical stop point, stop then. You don't have to stop immediately, but just acknowledge, and then stop when you can. When you're ready to proceed, counsel,
Thank you. Thank you. On behalf of Liberty Mutual, we are asking the court to reverse the trial court's decision compelling arbitration in this matter. We're specifically asking this court to determine and declare that legal issues relating to the interpretation of a matching statute, Connecticut General Statute Section 38-316E, must be judicially determined before any appraisal can go forward on this insurance claim relating to any cost of repair. The correct order is to resolve legal issues before any appraisal about cost or pricing. We're also asking the court to interpret the terms adjacent items in the matching statute to mean no more than a single elevation of the roof where the damaged shingles existed.
Counsel, there's a question from Justice Keller.
Thank you, Chief. Mr. Donovan, didn't we have an opinion? I mean, is there any right to appeal the decision of the two appraisers after an appraisal is done? So let's say that one of the parties is dissatisfied with what 2 of the 3 appraisers came up with. Don't we have a case that says that you then proceed as if it was an arbitration proceeding? So do you have any right to file a motion with the court to vacate the appraisal or any such remedy that way?
I think the only remedy would be in that circumstance, Justice, if you had a fraud or if the decision was somehow arbitrary or capricious. I think that would be the approach. But in most cases, the decision of the appraisers as to cost or pricing is binding on the parties.
But if you, all right. But couldn't you also file a declaratory action asking for a ruling on whether the definitions, what the definitions are under the matching statute? What does reasonably uniform mean? Could you do that as well? You
could, Your Honor.
So isn't it a good idea to have the appraisal done first to see how far off your position might be from the ultimate decision of 2 of the 3 appraisers?
No, it really isn't, Your Honor, and let me tell you why. The case law is pretty clear that legal issues like the interpretation of a statute are really not to be determined by appraisers. And I don't think there's any dispute in this case that coverage issues, interpretation of contracts or policies are not the job or the business of appraisers. And the reason we want that coverage issues should be judicially established before the appraisal is because, of course, it could limit the time involved in the appraisal, limit the scope of the appraisal, and also it would result in efficiencies for the parties. So why would the parties want appraisers to decide issues or assign costs or values to issues that they're not supposed to be engaged in?
But aren't appraisals designed to prevent all of this litigation that we're seeing here? And hopefully the outcome of the appraisal is something both sides can live with. You know, you keep calling it a coverage issue, but let's say I get in a car accident. I clearly have insurance that covers damage to my car. Then the issue becomes, is my car totaled or do you have to fix it? And the amount that gets paid to fix it versus the amount that I get for whatever the value of the car was at the time. And sometimes there's a big difference. Why isn't this the same kind of problem?
Because what the parties are disputing here isn't the cost of the shingles themselves. There's no dispute about the value of the damage. There's not a dispute about pricing. What we're disputing here, Your Honor, is the interpretation of a statute. The plaintiff is suggesting that because 4 shingles on the rear elevations of his 20-year-old roof were damaged, that the insurance company should pay for an entirely new roof on both the rear and front elevations of his house. He's not disputing, or there is no dispute about the cost of the individual shingles. It's really a question of, does the statute, the matching statute, require an insurance company to pay for an entirely new roof for someone who had 4 damaged shingles? And that issue has to be addressed in the first instance before we go to appraisal, because otherwise we're going to be back doing another declaratory judgment action after the fact. And then perhaps, Your Honor, that we'd have to do another appraisal to determine what was or wasn't related in terms of costs. And that just doesn't make sense. It's not efficient for the parties, and it doesn't make a lot of sense to have the...
But coverage is the risk, and you clearly cover the risk for wind damage, correct?
Yeah, there's no dispute about that, Your Honor.
So what you're talking about here is the extent of the loss, just like my example with a car. Are you going to pay to fix the car? Are you going to just give the let's say it's a 10-year-old car. You're going to pay to fix his damaged fenders, or are you going to just give him the book value of the car? That's not a coverage issue. That's how much they should get. That's sort of a claims adjustment issue, as your opponent's saying. You've already accepted coverage and you offered to pay a certain amount, and they're disputing the amount and the amount of repair that's required.
No, well, they're really disputing how the matching statute applies, how a statute that was enacted by the legislature applies to the loss. In your example, Your Honor,
the matching statute involves what the extent of the loss is going to be. It's all part of what the extent of the loss should be. And you don't even get to the matching statute until you have already accepted coverage.
That's true, Your Honor, but in your example of the motor vehicle, it's really a question of, is the bumper worth $1,000 or is it worth $3,000? That's not what's going on in this case. As I said, the cost of the individual shingles...
No, but it might be, do you have to replace both bumpers because of the matching thing?
Well, maybe, but again, in your example, the appraisers aren't being asked to determine what the terms adjacent items mean in a statute and what reasonable uniform appearance means in a statute, which they can't be under the prevailing case law here. The appraisers aren't allowed to make interpretations of statutes. That's why in this case, we're asking the court to determine that the terms adjacent items in the matching statute can mean no more than that slope or elevation of the roof where there was damage to the shingles. It's simply fair and reasonable and consistent also with the legislative history.
Wouldn't the court have more to work with if you brought this issue to the court's attention after the appraisal takes place and file something to challenge the result of the appraisal in court, which you can do pursuant to the arbitration laws? That's what one of these cases says. And then the court has what it needs to listen to your arguments because it's got all the information.
I don't think so. In fact, the plaintiff in this case suggests that that's this parade of horribles that will occur if our position is adopted. The advantage to doing it in the correct order, which the trial court had it right the first time, is to do the coverage issues or legal issues first and then deal with the factual issues later, because the legal issues in this case could have been addressed very expeditiously pursuant to the arbitration statute 52.410. As the court's aware, that whole statute was set up so that things could be done expeditiously, quickly, and cost efficiently. And I think the cases are very clear. Covenant Insurance and the Ice Cube, which is a very well-reasoned decision by Justice Bolden, which says that under that statute, the courts are allowed to decide antecedent, that's the key phrase, antecedent coverage issues before the case goes to appraisal. And it's logical, it makes sense. If there is a coverage issue in this case, or a legal issue about how the phrase adjacent items should be interpreted, the court can very quickly, expeditiously resolve that question before the parties go to arbitration and waste time about matters that may not have to be decided. I see there are some other questions, so I'll pause here.
Thank you.
Thank you, Your Honor.
Justice Daria, and then Justice Hager.
Okay, so practically speaking, then how does this work? Who takes it to court?
Right. Well, in this case, what happened is the plaintiff filed a claim under 52.410 seeking to compel the arbitration. Practically speaking, the court should, under the Covenant Insurance case, decide these antecedent coverage issues before the appraisal happens. That's how it would happen in practice, Your Honor.
And so if the judge does that, wouldn't there have to be? I mean, would one decision about construing the matching statute control, and or would you have to have a decision every time it goes to arbitration? 410 is implicated.
Sure. I think our hope here is that you adopt the Kamansky interpretation and our interpretation of this phrase adjacent items, that you construe the matching statute as the court in Kamansky did, Your Honor, and give guidance that no, consistent with the legislative history, claimants, when they have a damage to an isolated shingle or two, they don't get an entire new roof. If you do that, Your Honor, in this case, I think the guidance will be well received by the industry. And it's also,
but I mean, that's one dispute. I imagine there could be any number of disputes, maybe not any number, but a number of disputes. And I guess, I mean, I'll challenge your point that it would be more efficient when you talk about ADR. It's always a question, and this is what this is, right? It's an alternate dispute mechanism, and there's always the question of more efficient for whom. And who did the legislature want by demanding that these provisions be in your contracts?
yes.
Usually it's to save the court time, and the parties can decide whether that's a price of, whether you want to how far you want to pursue it. And why wouldn't you run the railroad to pick up where Justice Keller left off? Why wouldn't we turn it around and say, you get to appraisals, maybe they're close enough that you all will figure it out, and you could do an application to vacate an arbitration award based upon a legal issue. And I guess wrapped up, then you can comment on this, but wrapped up in this, I guess, is a notion that this is mandatory, this is compulsory arbitration. And so you may have a claim to a de novo review of that. If that were true, you had a de novo review, would you be okay with that after the arbitration?
I don't think so, because, Your Honor, I think it gets it in the wrong order. The legislative history, which is critical here, the legislature, in adopting the matching statute, really said what we're doing is codifying practice in the insurance industry, which is this practice of compromise. And they say repeatedly in that legislative history, in the discussions, we don't want to change the practice, which is to have insurance companies compromise with their insureds about what adjacent means, and to the extent that the items need to be repaired when they can't be matched. And in that legislative history, it says time and time again that the legislature did not intend that when you have damage to one slope of a roof, that you have to pay for an entirely new roof, especially in circumstances where the roof is 20 years old. And so I think if this court here adopts the interpretation of up to but no more than the replacement of an elevation or slope of a roof, then there's not going to be this parade of litigation or all these declaratory judgment actions, Your Honor. There's going to be an answer to that question, and you're going to give guidance to the appraisers, who then have to decide what's the fair cost for the replacement. So I'd suggest that the legislative history really is consistent with the interpretation we're urging you to adopt here.
Okay, thank you.
Justice Secker?
Thank you, Chief. Morning, Council.
Good morning, Your Honor.
I have questions, I guess, along similar lines. I'm trying to figure out, what's at stake here.
Sure.
Obviously, something's at stake. And the Amici have told us, I guess, what's at stake from the policyholders' point of view. Liberty Mutual has clearly sued out a lot more than $3,000 on the litigation. And I'm trying to figure out sort of why. One possibility, what you said, I think, in response to Justice Doria, is you're hoping for a construction of the statute that's going to eliminate future litigation, that's pro insurance company, I guess, from your perspective. That wouldn't be bad. I just, that would be helpful to you. And in future litigation and in appraisals. But the thing is, it seems to me that this is a very fact-specific inquiry, isn't it? I mean, I sort of doubt you're going to get a ruling from this court, and maybe my colleagues disagree, that in this particular case, on these facts, based on your beautiful color pictures in the appendix, that this is the right outcome. I mean, I can't see that happening. Your proposed rule about the slope and whether it's matching or not. So I just, isn't it more likely that you're going to get a rule that it's fact specific, but it has to be resolved by courts, and therefore every time there's a homeowner like the KLASS, they have to go to court, and it's not going to be worth it. I don't know how the KLASS are funding this, but there's no attorney's fees provision, right? So why would any rational policyholder spend $5 or $10 or $15 or $20,000 on a case in order to recover $3,000? So it's a very long question, and I apologize. But I guess my question is, isn't that, you gave a nice answer about what you're looking for. Isn't it a more cynical person like myself would say that maybe what you're looking for is fact-by-fact adjudication that'll put policyholders behind the 8 ball?
Okay. I guess I'm the eternal optimist, Your Honor, but I actually think that you can eliminate this concern about this fact-specific inquiry coming up in every case by adopting our proposed interpretation of the matching statute, which says that if the term adjacent items means up to but no more than the replacement of the same elevation where the damage is. And if the court does that, then you provide guidance for all of these claims going forward that is entirely consistent with what the legislature said when they.
Why would we ever say that? Why would we say it means the same elevation? I mean, that means that if you have a part of the roof lower that doesn't match, then that doesn't work, or some of the aluminum siding looks awful, but it happens to be 8 feet lower. It looks awful. Then it's no luck.
Well, what I'm saying, Your Honor, is that the term adjacent actually it has to have some meaning, and that's where the court can come in and give meaning to the terms adjacent items.
How about nearby?
Well, that's not what the legislature said. I mean, it's similar. It's similar to that. But again, the legislature, in adopting this, they specifically say that you're not entitled to an entirely new roof. And I just want to clarify, when I say elevation, Your Honor, in this case, what we're talking about is on the rear of the home, one entire slope over the dwelling and another slope over the garage had a total of 4 shingles missing on a 20-year-old roof. And what Liberty Mutual did is they said, well, we can pay you to replace those individual shingles, but you know what? As an accommodation, we'll give you the entire slopes the whole back of the house as new, but that's not enough. The plaintiff says, I want an entirely
this
new
will be
roof.
my, sorry to interrupt, sir. I see other people have their hands up. This will be my last question. Isn't it arguably a lot better to have professionals in the industry based on custom and practice making those determinations? I mean, apparently the statute itself came from custom and practice.
Sure.
You know, I assume the appraisers and adjusters will have a lot better idea about what's adjacent than I do for purposes of policy coverage. So wouldn't that be, I mean, we don't have auto property claims in auto cases, thank the Lord, right? Because everybody figures it out. They come for personal injury, but not for property. So why shouldn't we do sort of the same thing here?
Because the reason is that we have a case where the plaintiff is seeking an entirely new roof for something that had only damage on certain elevations. And that's not reasonable. That's not what the legislature said would happen. That's not consistent with industry practice. And we need guidance from the court here. Again, I'm the eternal optimist. I hope you adopt my interpretation, because that will stem the tide of plaintiffs seeking an entirely new roof when very discrete areas of the roof are damaged. I see there's another question, so I'll just pause there.
Chief, I don't know if you can see my hand was up. You may not be able to see it virtually. I think that's why Counsel Ray stopped.
I called on you.
It cut off. I didn't hear you. I apologize, Chief. Thank you. I was waiting, Counsel, for the Chief's go ahead. I guess my question is, you're asking this court, in the context of a very specific case and a specific fact pattern, to adopt a general rule that would apply going forward to all fact patterns. Now, it may very well be that the claim here may be not a valid one. I'm not suggesting that I'm adopting either view, but you're asking us to basically define what adjacent means and what can be included and not in the context of a very specific case, to then have applicability going forward to all cases. And so I guess my questions are exactly like Justice Ecker's question. Why shouldn't that be something that under the contract, the insured has a right to get an appraisal, to get an expert to say, look, it's not going to make sense to have two slopes looking one way and the rest of the roof looking the other way. It may be a situation where something adjacent, if it's not fixed, it won't fix the problem in a different fact pattern. So you're asking us to basically adopt a rule that would have general applicability when it's very fact specific to this case. Can you address that?
I sure can, Your Honor. Thank you for that question. First, we're asking you to do two things. Number one, to make sure that these antecedent coverage issues are resolved before cases are sent to appraisal. And I think that there's a system in place for that to be done expeditiously. So at a minimum, we'd ask you to do that, to say, no, you can't wait and hold these legal issues on interpretation till after the fact. But then you're right, Your Honor, we are asking you to interpret the statute. And I think you can based on its text, because the text of it is clear. When we say adjacent, I think the court can adopt a rule, a very broad rule that says up to, but no more than the replacement of an elevation or slope that can have general application beyond that. And I do come back to this, Your Honor, again, the legislative history gives this court a great deal of guidance, because the court said what we're doing here by codifying this statute is to make sure we're basically codifying what's already happening, which is insurance companies are giving the benefit of the doubt to their insureds. They're paying more than they should for these claims, but there can't be more than that slope or elevation or side of the house, because that's just not fair or reasonable or what was bargained for. So I do think that you can do both. You can say that legal issues consistent with the covenant insurance case have to be resolved and should be resolved before appraisal happens, but also give general guidance on this case, in every case, that the term adjacent is a limitation. It's not this broad claim that says you can have an entirely new roof. It's trying to limit the amount of the damages consistent with industry practice.
Thank you for answering my question. I did see the notice that your time went up. I'm going to yield back to the chief.
Thank you.
Justice Keller, I see your hand is up.
I can ask it on rebuttal, Chief, so that the other side can start. Thank you.
Thank you, Counsel. Thank you, Justice Keller. Thank you, Counsel. Attorney Lamont.
May it please the court, this is Michael Lamont on behalf of the appellee, KARL KLASS. I'd like to focus my argument on the issue that was briefed to the trial court, which is specifically an insured's right to appraisal when an insurance carrier has argued there is a coverage dispute. The only argument that Liberty raised at the trial level was its claim that there was an outstanding dispute over coverage, and that was required to be decided prior to appraisal. We ask that this court affirm the decision of the trial court and find that an insurance carrier's argument that there is unresolved issues of coverage does not preclude appraisal, so to protect the rights of every Connecticut insured.
How does it do that, Counsel?
I'm sorry, Your Honor?
How does it do that?
Well, it holds in conformity with the Giuletti decision of 30 years ago, Your Honor, because the Giuletti court rejected the exact same argument that Liberty Mutual is making here today. And the Giuletti court determined that if insurance carriers are allowed to circumvent the appraisal process and stop the appraisal process by simply claiming there's a coverage dispute, that would render the appraisal clause illusory and would effectively destroy insured's rights to appraisal. And that's what happened here, Your Honor. Oh, I see Justice Keller has a question.
If you could finish, because I'm not sure that.
Oh, certainly.
Yeah, if you can finish your answer, because I'm not sure that I'm satisfied with it.
No problem, Your Honor. So in this instance, there was no coverage dispute. There was no dispute over coverage. The subject policy provides coverage for wind damage. It was undisputed that the KLASS home suffered wind damage. It was further undisputed that Liberty provided coverage for wind damage. It was only after Mr. KLASS's contractor submitted an estimate for roof replacement, as opposed to the repairs that Liberty was suggesting, and Mr. KLASS then demanded appraisal, that Liberty manufactured a coverage dispute.
Well, Counsel, this is a 20-year-old roof, and 4 tiles were damaged. I don't think it's unreasonable for Liberty Mutual to look at this and go, well, wait a minute, you're asking us to repair an entire roof when 4 tiles were damaged. What comes in then is the matching statute, and we have to deal with that issue. Isn't that correct?
Well, Your Honor, so a couple of things. One is Mr. KLASS did not demand appraisal based on the matching statute. That's what Liberty has said time and time again. But if the court looks at the history, it was Liberty that injected the matching statute into this matter. Mr. KLASS demanded appraisal based on his contractor's estimate, and then Liberty rejected appraisal and issued a coverage declination based on the matching statute. But to Your Honor's point, and counsel has said many times today that this is a 20-year-old roof with limited damage, and Mr. KLASS wants the court to give him a whole new roof. That's not what Mr. KLASS wants. Mr. KLASS wants a team of experts, an appraisal panel to determine what the reasonable cost to repair the roof is. The appraisal panel may come back and say, you don't even get that back half of the roof. They may say all you get is 4 shingles. And if that's the case, that's the case. So we're not asking this court or any other court to determine what's the reasonable scope of repairs. We believe that a team of professionals, adjusters, estimators, and other experts should make this decision. I believe Justice Ecker discussed that previously.
I suppose that's part of my problem with this, because I've heard what Justice Ecker's questions were, and this is a bit of an unusual situation with a 20-year-old roof. Most insurance companies won't even insure a 20-year-old roof. So it's an odd case.
Well, I mean, Your Honor, I think that the age of the roof, is not necessarily an issue here, because Liberty Mutual has conceded that the roof suffered damage. And at the end of the day, to Your Honor's point, the panel may come back and say, you're only getting 3 shingles, that's it. But it's not just the matching statute that Mr. KLASS demanded appraisal based on. His contractor said, this is the work that needs to be done to fix your roof. And pursuant to the policy language, because there's a dispute here, that should go to an appraisal panel to determine that scope. And I can discuss the fact that there's significant extra-jurisdictional law that supports that premise. However, I do see that there's other questions. So
I was going to say that, counsel, thank you. You answered my question. I appreciate it. And there are other justices waiting in line. Justice Keller.
Thank you, Chief. Good morning, Mr. Lamolt.
Good morning.
I wanted to talk about the first claim that the court erred in granting re-argument and changing its mind on the order of the appraisal. When you filed your motion to re-argue, there's case law that says that you don't get a second bite of the apple, but if you bring something to the court's attention that the court overlooked or the court may have misinterpreted, you can file a motion to re-argue. Is that really the basis? Was that the basis for your motion to re-argue?
Yeah, yes, Your Honor. I mean, we believe that both, Judge Hiller overlooked the controlling decision in the Giuletti by this court in Giuletti. In addition, that Justice Hiller, you had a misapprehension of the decision in Milligan, because in that case, the Milligan decision, the court did not say that appraisal cannot happen until coverage is decided. Rather, in that case, there was a specific allegation that the insurance company had violated a specific statute, and the court said that can't go to the appraisal panel, which we completely agree with.
And I was going to ask this of your opponent, and I still might, but the third issue looks like they're asking for an advisory opinion. Did the Superior Court's decisions in 2 Superior Court cases that came before this one appropriately interpret the Connecticut matching statute? In fact, the trial court here never addressed that issue, correct? All it did was order an appraisal. It didn't decide whether the 4 tiles, you only need to replace the back half of the roof. It didn't do any of that. Is that correct? We don't have any factual findings from the trial court, correct?
You are 100% correct, Your Honor.
So how are we able to decide the question your opponent's asking us to decide, which is how the matching statute applies to this case?
Well, I don't think you can, Your Honor, and I think we have filed a motion to strike based on that issue. I am happy to discuss the matching statute, though, and why I believe that counsel's interpretation or request of this court is essentially unworkable. What Liberty's asked the court to do is issue a bright line ruling to say that the Kamansky decision should be applied essentially in every instance where matching comes into play. Unfortunately, that would yield absurd results, Your Honor, because the matching statute itself and counsel's relied heavily on the legislative history. But if the court will look at the legislative history here, it's very clear that this statute was not intended as a limit as to the insurance company's obligations. Rather, it was intended to address those few carriers who refused to consider undamaged building components. And for that reason, the statute was employed to say you need to also consider undamaged building components. And specifically, Representative Megna testified, this is a floor. It's not a ceiling. This is a floor that you need to make this consideration. Moreover, during his testimony, repeatedly, Representative Megna says that this is a subjective statute that's based on the facts of each claim. And to Justice Ecker, and I believe Justice Kahn's point, this is a factual determination. The only reason the Kamansky court could reach a decision was because both parties had filed motions for summary judgment. And the court determined there was no absence of material fact here. And so he could interpret that statute as a matter of law. That we don't have that here, and we're not going to have that in every single claim because it's a factual issue, it's subjective, and that's what the legislative intent was here. And specifically, even in Kamansky, Judge Shapiro says, he references this court's decision in the Wells case, the Wells v. Town of East Windsor case, and says the term adjacent has no fixed meaning. The term adjacent is dependent on the facts at hand. So again, this is a factual inquiry. It's not an issue for a court to determine as a matter of law and issue a bright line ruling. Moreover, if this court were to issue a bright line ruling in conformity with what Liberty's asking, it's not going to just apply to shingles and roofing. To shingles and roofing siding, Your Honor. This applies to every single building component. So you could have a kitchen fire with a fire that just damages the cabinets above the stove. But maybe you have cabinetry on all 4 walls of the kitchen, custom cabinetry. They no longer make those cabinets anymore. The manufacturer went out of business. If this court is to issue a bright line ruling the way that Liberty has asked it to, the insured would only be entitled to replace those cabinets and the cabinets immediately adjacent. And it would have a completely mismatched situation throughout the rest of the kitchen. This applies to carpeting, to wainscoting, to wallpaper, every single building component. And these insureds are going to be left in a position less than they were prior to the loss, which defeats the purpose of indemnity. So to apply the matching statute in the manner that Liberty's asked this court to do would yield unworkable and absurd results, and frankly.
Thank you.
No problem, Your Honor. I believe is there another question pending?
Yes, there is. There's Justice Doria.
Yes, thank you, Chief. Do you agree that the appraisal statute is a mandatory arbitration provision, essentially?
Yes, Your Honor. Yes. If either party demands it, yes.
Right. And so would you agree that if there are legal issues, that review would be de novo if somebody brought an application to vacate the arbitration?
I believe, Your Honor, that this court in the Kellogg decision addressed a motion to vacate pursuant to 52-584 and found that it wasn't a de novo review. However, that's not the only way to challenge an appraisal award. Counsel mentioned that you could file the application pursuant to 52-584. However, this court in Giuletti also made it clear that an insurance carrier can still contest coverage via declaratory judgment action. So in that instance, it would be a de novo review of coverage. So even after the appraisal award is rendered, if there's a dispute that a portion of the award or the award itself is not covered, the insurance carrier is free to file an action to contest coverage, in addition to a motion to vacate pursuant to 52-584.
Do you think that I should know this? Kellogg I authored that, but was that a mandatory arbitration provision?
I believe it was, Your Honor. I think we're talking about the same type of appraisal clause.
Okay.
I believe so.
All right. Thank you.
Thank you, Your Honor. So where I was getting at is that there is no coverage dispute in this matter. Liberty Mutual simply created a coverage dispute, and that is why, and that was its only basis to try to defeat appraisal. And the Giuletti decision specifically warned against that and protected against that, and found that if carriers are allowed to do that, it's going to destroy the insurance carrier's right to appraisal. I see. Before I move on to my next topic, I see there's a question pending.
McDonald.
Yeah, I was trying to get in there before you pivoted. So, I mean, what would happen in a situation if there was a specific exclusion from a policy that Liberty, doesn't cover leaking oil tanks, and your client has a leaking oil tank, and they decline coverage? Could you just still move for appraisal?
I mean, you could move for appraisal, Your Honor. I think that appraisal award would be useless. That type of litigation would not yield you any sort of results, because again, the insurance carrier could just challenge the appraisal award and say, well, there's no coverage for this.
Well, so what's the wisdom that underlies that? Why would you go to the expense of doing the appraisal and going through that entire process if the coverage issue was clear?
Well, like I said, Your Honor, in that instance, that would not be advisable. But the reason that you still allow for appraisal,
whether it's advisable or not, why would it be permissible?
Well, if an application has to be filed to compel appraisal, and that coverage issue is raised, and it's a specific coverage issue, and the court finds there's no way that this matter should go to appraisal, then yes, in those limited circumstances, the court can say, no, you can't go to appraisal on an issue. It's very clearly excluded. There is no coverage for something like this. But those are very limited issues, Your Honor, and obviously that's not a situation we have here. And the reason that this court in Giuletti said you get appraisal before coverage determinations are because otherwise you would have instances like we have here, where the carrier simply is inventing coverage disputes in order to avoid appraisal. And that would essentially destroy the insured's right to appraisal. But in your scenario, Your Honor, if you do file an application pursuant to the statute, the court would have the ability to say, no, this type of matter cannot be arbitrated. It's more of an arbitrability issue, because it's very clear here that that's not covered under your policy.
And I gave you a stark example, but you could have a situation where there was a hurricane and the tree came down, took out the roof, and punctured your oil tank. And there's other things. So there's some things that would be covered, other things that wouldn't be covered. Why wouldn't you narrow the scope of what's in and what's out of coverage first before you can actually ask somebody to appraise the value of the loss?
Well, because the appraisal process and the statutes that form the ability to compel appraisal, it's meant to be an expedited process, Your Honor, to capture those damages immediately after they occur. And then if there's a dispute over what's covered and what's not, then that can be litigated thereafter. But the issue is, if you're going to litigate coverage first, that's going to take years of time. Moreover, when you're going to litigate coverage, you're also generally going to litigate damages. And that was exactly what happened in Giuletti. Is they litigated coverage and damages, and the court said, well, you can't now appraise the damages, that you've lost that right. If you wanted to appraise the damages that happen to have that would have to happen prior to the jury's determination of coverage and damages here.
Thank you.
So what I'd like to talk about now is what is the dispute between the parties, because the dispute is simply over the scope of repairs. And I believe counsel spoke with Justice Keller about this previously, and counsel said, in akin to an auto accident case, it's, well, what's the cost of the bumper? And Justice Keller mentioned, well, maybe it's actually, do both bumpers need to be replaced? And that's what appraisal is about. Courts throughout the country, almost all courts throughout the country, have held that appraisal includes scope of repairs. It's not just the cost of repairs, it includes the scope of repairs. The most off-cited case is the State Farm Lloyds v. Johnson case from the Supreme Court of Texas, which did not involve matching. However, it did involve damage to roofing shingles. And that court specifically held that the appraisal process was not limited to only those shingles which both parties agreed were damaged, because if that was the case, it would basically render the appraisal process useless. Courts throughout the country have found in conformity with this. This is not a novel decision. We have decisions from the Supreme Court of Minnesota. We have decisions from the Seventh Circuit, from the district courts in Maryland, Colorado, and Indiana, all saying that the scope of repairs is part of the appraisal process. Moreover, we also have a number of decisions. Yes, Your Honor.
So, counsel, what would have happened in this case if Liberty Mutual said, okay, you want an appraisal, we'll appraise the slope, that one part of the roof, not the tiles, but the entire roof side of the roof.
The one slope of the roof? I think that would be an impermissible limitation of the appraisal clause.
Why?
Because there's
a situation where you're differing on the extent of the repair, and then they would of course say that they gave you a full estimate of the repair.
Well, obviously that's Liberty Mutual's position, and in this situation, the homeowner's position, their estimate of damages includes both slopes. So the dispute does not just lie within the one scope, within the one slope. It's also as to the front slope. And again, I mean, this issue wasn't litigated. The issue wasn't litigated before the trial court, but the reason for the full scope of repairs is not just for matching purposes. That's what Mr. KLASS relied on by his contractor for what needed to be done in order to address the damage here.
Yeah, and I suppose it's a question of fact that I can't even figure out why it would be the entire roof, every side of it, if there were 4 tiles on one slope damaged.
Well, again, I don't want to get into facts that were before the trial court.
No, that's fine. Those facts aren't before us.
Understood. Thank you, Your Honor. So going back to where I was, the scope of repairs has been held to be part of the appraisal process in almost all of the jurisdictions throughout the country. In addition, there's several jurisdictions that have specifically said issues of matching also go to the appraisal panel. You know, the Minnesota Supreme Court made this decision in the Cedar Bluff case that's referenced in the appellee's brief. And recently in New York, in the Pottenberg v. Dryden case, the New York court also said that issues involving the matching of undamaged items also are part of the scope of repairs and go to the appraisal panel. Most recently, in Massachusetts, in the Edelman decision, and it's important because in Massachusetts, there is no matching statute, and there was no case law or precedent to say that an insurance company had any obligation to match undamaged building components. So in Edelman, the court first needed to determine whether or not there was an obligation to match undamaged building components. And they found that. They said, yes, you do have an obligation to match these undamaged building components. However, the court would not reach the issue of what is the scope of necessary repairs and what extent of matching damage there actually is. And they specifically said that this is a question for a reference panel. A reference panel in Massachusetts is akin to an appraisal panel here in Connecticut. So in the Edelman decision, they said, you have a duty to match, but we don't just determine what scope of repairs is used for matching. That goes to the appraisal panel. It's a question of fact. And Your Honor, Liberty Mutual has indicated that this interpretation of the statute is necessary and it's specific. Oh, I'm sorry. There's a question pending?
Yes, there is, Justice Keller. Counsel, the way we do this is you could finish your thought. Just when you get to the next place where you could pause, we'd like for you to pause.
Understood. I was moving on to my next point, so that's why I figured we had time. Thank you, Your Honor.
I just, for the edification of whichever justice may have to draft this, the defendants had an estimate of 5,000 or 5,100 or thereabouts, but they end up not paying. Then there's talk about upon completion of the work, plaintiff would receive another 2,500, and then something about an ice and water barrier. Why doesn't he get the full amount of the estimate? Is there a deductible here?
So, Your Honor, this is a replacement cost insurance policy, which means you're entitled to the actual cost that you spend on the repairs, as long as opposed to actual cash value policies where you can't get more than the actual value of the roof. So, to Justice McDonald's, to Justice Robinson's point before the Chief's point, because it's a 20-year-old roof, the age and the depreciation don't come into consideration when you're addressing the replacement cost value. That comes into consideration for the actual cash value. So what happens is, while the insured is entitled to the replacement cost value, initially it's depreciated down to an actual cash value, and that's what's paid at the outset. And then once the repairs are completed, you can collect the depreciation to arrive at the replacement cost figure. So that's how that works under this type of policy. I believe the ice and water shield you're talking about, Your Honor, that is a code upgrade necessitated by building code. And again, you don't get paid that money until the repairs are actually completed. So that's why that was conducted initially.
Thank you.
No problem.
Thank you for that, counsel. I'm always amazed how much of an education you can get by sitting in one of these.
Thank you, Your Honor. Thank you very much. So we've discussed the fact, or I've discussed the statute and the legislative history behind the statute. But what is also important to note here is, because I've said many times that that basically Liberty invented a coverage denial here. And what's important to note is the statute specifically says when a covered loss occurs, this is what needs to happen. So Liberty Mutual utilized this as a basis to issue a partial denial of coverage and avoid appraisal when it's very clearly not a coverage issue. The matching statute is not a coverage issue. It only comes into play when there is a covered cause of loss. So for that reason, that's just indicative of what insurance companies can and will do if this court rules that appraisals can be stopped when there's a dispute over coverage, or appraisals cannot happen when there's a dispute over coverage. Insurance carriers like Liberty Mutual will take statutes that have nothing to do with coverage, inject them into the claim, and use that to claim that there's a coverage dispute and stop the appraisal process dead in its tracks. I'm a convenient stopping point if there's a question pending.
I think that's from Justice Keller's last question.
Oh, okay. Thank you, Your Honor. So that's the major concern here, Your Honor, Your Honors, that if the court finds that all an insurance company needs to do is say there's a coverage dispute, and then that stops the appraisal process, there will be a floodgate of litigation. Because all an insurance company needs to do is say there's a coverage dispute, and the insured's only recourse is to hire an attorney and litigate coverage. That would essentially kill the appraisal process, the appraisal right dead in its tracks. What I'd last like to focus on is a little bit of what I believe Justice Eckert talked about before, which is that these factual questions about the scope of repairs are best left for insurance industry experts. Generally, when you have a covered claim, the insurance company adjuster and the insured or their representatives, their contractors or public adjusters, will adjust the claim. They'll try to resolve it. They'll try to determine a scope of damages and an appropriate cost of repairs. And when that can't happen, when you cannot agree on the appropriate scope and the appropriate cost, then the insured has the ability to demand appraisal. And what that then happens is experts determine what's the appropriate scope of repairs, and that's how the appraisal award is determined. And that's exactly what Liberty Mutual did in this case, Your Honors. Liberty Mutual hired an engineer named Aaron Gill, who came out to the property, did an assessment of the property, and said Liberty's repair scope is appropriate to reasonably match the tiles here. They hired an expert to do that. But when Mr. KLASS demanded appraisal so that he could have his own expert, make a determination as to the scope of repairs, Liberty Mutual said, nope, this is an issue that needs to be determined by a court. A court needs to interpret this statute. We can't have the appraisal panel do that. So by doing that, Liberty is ignoring what it's already done in this case. So what needs to happen is that these experts need to inspect the property and to determine what the scope of repairs are. It can't be a court issuing a bright line ruling. As I've already discussed, if the court is to hold in conformity with Kamansky and apply that to every single claim, it's going to have unworkable and absurd results. Rather, the matching statute is specifically supposed to be subjective and based on the facts of each individual claim. For that reason, the appraisal panel are the best people to determine the scope of repairs and the cost of repairs. And that's what's been held throughout the country through almost every single jurisdiction. So that's what we're asking for this court to do.
Why would we have to make that decision instead of the legislature?
I'm sorry.
Why are we in this building instead of across the street, where they're setting the policy instead of us looking at it and saying, what's the statute really mean? I mean, if we come up with interpretation that either the policy owner or the insurance company hates or loves, it's whichever direction we're going to go in, we're going to go in a direction what we think is the proper interpretation of the statute. This other stuff that sounds a lot more like policy than anything else, why would, and I suppose this is a question for your opponent, not you, but why would we be doing that?
So I agree, Your Honor. If this court is going to interpret this statute and issue a ruling on that point, my suggestion is that that ruling should be that the statute is subjective and it's based on the facts of each individual claim. And therefore, those facts drive the application of the statute. A bright line rule would not work. And I'm not saying the Kamansky court got it wrong, because in the Kamansky decision, Judge Shapiro had all of the facts. He had cross motions for summary judgment. He determined there is no factual dispute here, and based on these facts, this is my interpretation of the statute. But that's because the parties asked him to do that and filed those motions.
Thank you.
I have, unless any justices have any further questions, I don't have any further argument at this time. And I thank you all for your time.
Thank you, counsel. Seeing none, I'll call on Mr. Donovan. Mr. Donovan, I'm going to start right where I left off with opposing counsel.
Sure.
Why us? Because I'm imagining a situation when I look at my own home, which is a middle hall colonial that is styled like a cape. And to make it look like a cape, they use three different roof lines if you count the garage.
Sure.
So you have a roof line next to a roof line to give you an optical illusion of it looking like a cape. If I use your interpretation of the statute, then if one of those roofs are damaged, then I can only have that roof repaired, not matched with the main roof. That seems rather odd. So why isn't it subjective?
Well, it's not subjective, Your Honor, because first off, the legislature created a statute, which of course you folks interpret statutes every day and give meaning to them every day. And the statute says adjacent items, you have to have matching with adjacent items. And that therefore becomes your role to interpret what that means. This idea that we have to have fact-specific inquiries and things of that sort, it really doesn't hold true. The
situation I'm talking about is literally they're less than an inch apart. It's just the depth.
Sure.
So is it adjacent? I don't know. According to you said, if it's a different elevation, it's not adjacent. So based on what you've said, it would not be adjacent. Yet they're right next to each other.
Right. And I think the statute is clear that we talk about adjacent items that so you can conform and get this reasonably uniform appearance. It actually only applies if you can't replace that item and make this uniform appearance. The rule we're suggesting, Your Honor, is consistent with what the legislature said repeatedly when this issue came up, which is that there's a limitation here, and you don't get an entirely new roof when there's only damage to isolated portions. That adjacent really should mean the areas around that specific shingle. But here, the rule we're suggesting you adopt is even more generous than that, Your Honor. We're suggesting that we give a limitation that says you replace the entire elevation or scope of or slope of the roof. And that's more generous than I think actually may be necessary under the circumstances. And that you have the benefit of the legislative history, which clearly says that we're not going to give people new roofs when you have one shingle damaged on a slope. We didn't invent this issue, Your Honor, in this case. We didn't create this issue. The appendix has the letter from Mr. KLASS himself in November of 2018. This is appendix 240.
And I see there's other questions, but what would happen if the color you were using, you use I was riding my bike the other day, I saw blue roofs.
Sure.
And so let's say they don't make the blue shingles anymore. What happens then?
Well, again, I think the idea would be you'd attempt to create a uniform appearance through some mechanism. I mean, I'm sure at Home Depot they have a product where you can go and spray on colors to shingles and other things like that. But if you can't, then I think you're going to get a new slope of the roof that you can try to create this uniform appearance to the extent possible. But the idea, Your Honor, that the legislature thought you'd get an entirely new roof when
that's what I'm talking about. I'm just trying to figure out what this adjacent really means. And in the situation I talked about, there are two roof lines, similar slopes.
Sure.
But there's just two different roof lines that you can see at one time.
Yeah. And I think the legislature has already said what the term adjacent, or the court has already said what the term adjacent means in that Wells decision that talks about near or proximate to. You know, just to go back, Your Honor, the fundamental thing is the insurance policy covers damages to physical loss to a property. It doesn't cover aesthetics of a house. It doesn't entitle you to an aesthetically beautiful house. It covers to replace damage to physical property.
Thank you, counsel. I know you have very limited time, and there are two other justices, so I'm going to call on them. Justice Ecker, then Justice Keller.
Thank you.
Counsel, I was wondering what how you respond to the. I mean, there's some cases that are relied on by the plaintiff. Mentioned them again at argument. you respond in your reply brief to Edelman, but you make no mention of the Minnesota, Texas, New York, Seventh Circuit cases. Is that because you're crying uncle, or and concede that they apply but they're wrong, or for some other reason?
I think they're flat out wrong and inopposite because, Your Honor, they don't involve what we have here, which is a matching statute that created a limitation on the terms adjacent. So they really don't apply in this circumstance. I think Kamansky is the better reasoned rule here because that's a Connecticut court applying the statute and saying, hey, there's a limitation. You don't get a new roof. You get
counsel said, opposing counsel says that there's a leading case in Texas and then there's a Minnesota case that say that the scope of the repairs is, within the appraisal. It's not a matter of coverage. And then there's some that specifically apply it to matching clauses, whether they're statutes or whatever. Right. What do you say to that?
But this isn't a scope of repair issue. If we want to talk about inventing phrases or terminology, that's what the plaintiffs have done here, is to try to say this is a cost issue or a pricing issue or method of repair issue. It is none of that. It's the interpretation of a statute. It's exactly what does the term adjacent items mean. And I'd suggest, Your Honor, again, that's where the legislature intended a limitation on it, and they intended for the court to resolve it. No appraisers in the country are involved with the interpretation of policies. And what Justice McDonald said should not be overlooked. They are not called upon, appraisers who are determining costs and things like that. They're not asked to determine whether an oil or pollution exclusion applies in a given case. They're not asked to interpret how a contract applies. And I think the amicus briefs concede that, and even the plaintiffs themselves concede, Your Honor, that they don't get involved in that. And it doesn't make sense to have them do that to have a court do that after the fact. For all the reasons outlined in the Ice Cube decision and the Covenant case, these antecedent coverage questions should be resolved. So to the extent
thank you very much for your answer. I think Justice Keller has a question, and I'm done. Thank you.
Thank you, Your Honor.
Thank you. Why am I totally, my look at this case is we need to decide whether there is even an antecedent coverage issue involved. And if we determine that there is not, the trial court never interpreted the definitions of adjacent. The trial court never decided whether it was okay for you to just do the back roof or whether the plaintiff should get the whole roof. And that's going to require factual findings. We don't find facts. So to me, there's unless we find that this is a coverage issue, I think that the appraisal should just go forward, and then you can file your motion to vacate and ask for your review of whatever the appraisers decide pursuant to our arbitration laws, or you can file a declaratory judgment action if you want to go that far, over a dispute of about $3,000. Am I off the wall in looking at the case this way?
I don't want to say you're off the wall, but I'd say maybe off the chair a little bit, because it isn't the way you describe it. We're not asking for an advisory opinion. All of these issues were joined in the case. The matching statute was. But
did the court decide them? Did the court make any decision about adjacent?
They don't.
What's adjacent and what isn't?
They don't. I don't think they need to, Your Honor, for you folks to be asked to review and interpret a statute that's clear given its legislative history. I think this is something that you can do very easily, given you look at the statute, you interpret the text, those words have to have meaning, they're limiting in scope, and you can adopt a rule. Or alternatively, you should send it back down below and say to the court, you have to decide these coverage issues and address these coverage issues before there is an appraisal, because it just doesn't make sense to go to appraisal, especially, Your Honor, when in our policy itself, there's a very strong 30-day rule, which says within 30 days of an appraisal award, the insurance company has to pay it. So that's not fair to the insurance company, because then we're going to be confronted with bad faith claims because we don't pay an award and we take a DJ coverage action after that. That's setting us up for a disaster. Talk about a parade of horribles. What the better course is, and the way that the courts in this state have said, is antecedent coverage issues should be resolved first. Again, Justice Bolden in the Ice Cube case and in this court in Covenant clearly say antecedent coverage issues before appraisal. It's the logical approach. And I don't think you're going to take years, or this idea that it's going to take 10 years to resolve these issues. If it's done pursuant to the 52-410 statute, it's going to be expeditiously handled. It's going to be addressed. And then logic would be you have one appraisal, not 2 or 3 or 4, one appraisal that discusses issues that are appropriately before the appraisers.
Counsel, your time is up. If you'd like to wrap up, you may do so.
So I just ask again, thank you, Your Honor, just briefly, I think that the court should say that the trial court's decision, the first decision, was the right one. They got it in the right order, coverage first, then, or legal interpretation of statute first, then you go to appraisal. And I think that this court is well within its power to interpret the phrase adjacent items to mean up to, but no more than replacement of a single elevation or slope of the roof. And I thank you, Your Honor.
Sorry about that. Thank you, counsel. Thank both of you. I appreciate the argument. With that, we are adjourned until tomorrow morning. I will meet the justices in the virtual conference room, let's say in 10 minutes. Thank you, everyone.
Thank you, Your Honor. Have a good day.